Okay, we are in week 8 of your bankruptcy course. We are doing chapter 10 in your book. So, week 8, we are going to talk about, we're going to continue to talk about the chapter 7, bankruptcy, the individual consumer, the consumer debtor case. And we're going to explore in this chapter, what does a creditor do, right? If I'm a debtor, I've made a decision, I've gone through consumer credit counseling, I've made a decision that I need to just wipe the slate clean, I need to start over again, and so I file for a Chapter 7 bankruptcy that gives me protection through the automatic stay, stops everything so that I can breathe, figure out what we're going to keep, what we're not going to keep, what we're going to reaffirm, what we're going to redeem. And where does that leave a creditor? Well, there's different kinds of creditors. Remember, we have secured and unsecured. Secured creditors have filed their financing statement, their security agreement with the county recorder's office. They've perfected their security interest in that piece of whatever chattel, whatever it is that they've used as collateral. Remember, unsecureds didn't. Unsecureds said, I'm going to take a chance on you, debtor. I'm going to give you a higher interest rate so that over time you'll pay me interest that hopefully will balance out if you default on whatever credit I've given you. Okay? So what do we do if we are a secured or unsecured creditor? First of all, remember in our schedules, there's a schedule for secured creditors and there's a schedule for unsecured creditors. If we have a fully secured creditor, it goes there. If we're only partially secured, what does that mean? Well, let's say that I am a mortgage company or a bank, and I loaned money for Susie to buy a house. And at the time Susie bought the house, well, it was a pretty good deal. I loaned Susie $75,000. The house was valued at $100,000. So chances are the collateral is worth more than the money I loaned for her to buy the house. I have a security interest in the house, so I'm over-secured. There is more security interest in that house than what I loaned money for. No problem. What if the housing market crashes? And now Susie's house is only worth $50,000. She owes me $75,000. I'm under-secured. There isn't enough security interest in that piece of property to give me the value of my loan. Now, part of that could be that I just made a bad loan. Part of it could be the market changed. Bankruptcy court deals with that. If I'm oversecured, there's going to be a bifurcation means splitting in two parts, right? Bicycle two wheels. We're going to split the secured portion, the $75,000, from the unsecured portion, the $25,000. If I'm undersecured, I'm undersecured. There's just no good way around it. If I'm a creditor and I'm on the matrix for the bankruptcy petition, the clerk of court's office is going to send out a notice saying, "Hey, Diane filed for bankruptcy, and you're listed as a creditor. You need to protect your interest, Mr. Creditor, by filing what's called a proof of claim." Okay, and the proof of claim has to have certain parts to it. By the way, if you don't file a proof of claim, you've walked away from it. If you don't protect your interests as a creditor By filing a proof of claim, you're kind of out of luck. Okay? So, if we have a proof of claim, you need to put in that proof of claim an itemized statement of interest, fees, expenses, or other charges sought in addition to the initial indebtedness. If a security interest is asserted in debtor's property, the amount of any arrearage as of the date of the petition. So if I haven't paid my house payment for 3 months, in my proof of claim I have to say hasn't paid that for 3 months. Okay? If a mortgage is asserted in a debtor's principal residence, an attachment, which is a specific form, bankruptcy form, must accompany the proof of claim providing details of the outstanding loan as of the date the petition is filed. And if the claim is based on a revolving or open-ended consumer credit account, a credit card, a statement containing details of the last transaction, payment, and posting on the account. Okay? You're a creditor, you should have that information. It should be right at your fingertips. But that must be included in your proof of claim if those situations apply to your particular loan. If the trustee says that that you're going to participate in some kind of a distribution, the trustee gets to kind of wiggle around who gets what and what amount. And that's called equitable subordination, where somebody is put below somebody else. And this goes into how the bankruptcy code says the trustee must pay people, but they also have some kind of discretion as to who gets what dollar amount when it comes to a distribution from a consumer account or from a consumer bankruptcy. Okay, so as claims are filed, the clerk's office is going to keep a list of them, and that's going to be called a claims docket. And one of the things the bankruptcy trustee can do is they're going to look at all of these claims that are listed in the claims docket, and unless there's an objection that's filed, the claim is deemed to be allowed. Now, who can make an objection? Well, the trustee could, if the trustee says, what are you talking about? Or another party could say, hey, wait a minute, you didn't file your security agreement and financing statement ahead of me. I filed it ahead of you. Or, maybe a debtor will say, hey, I don't know that amount. That doesn't make sense. So if the claim is not objected to, it's allowed. Okay? And if the claim is a secured claim, the bankruptcy trustee is actually going to pull the security agreement and the financing statement from the recorder's office. Okay? If there is interest that a creditor is asserting, most trustees will stop that interest at the date of the filing of the petition. Okay? The creditor usually cannot get post-petition interest. Pre-petition interest, yes. Post-petition interest, you're going to have to make a really strong case for why that would have to happen. You're also not going to be able to, if you're a creditor, be able to collect for unmatured interest. So what that means is, if I take out a loan, the payoff is going to include a bunch of interest. If I file for bankruptcy, you as a creditor don't get to say, hey, if they would have paid out this entire loan over a course of time, we would have gotten this much interest. You don't get to assert that. Okay? Now, what happens to the property of the estate? Well, we have those exemptions. Remember those exemptions that we listed in our schedules for our petition? that are taken from federal or state, doesn't matter, whichever one is the higher exemption, that's what you're going to put down on your petition. And you're going to, the bankruptcy trustee is going to look at the fair market or liquidation value, depending on what it is, of the claim, of the secured interest, and then take the exemption, subtract it, or set it off from whatever the value of the collateral is, if it's a secured claim. And then it's going to say, is it worth it to go through an auction? Are we going to lose money on this? Or if it's an unsecured claim, are we just going to walk away from it? If it's a secured claim, is the debtor either going to redeem or reaffirm this particular piece of collateral? Debtors sometimes will try to challenge exemptions. Usually they're not successful, but they will try to say, hey, the exemption shouldn't be that high. Those are pretty cut and dry because they're statutory. The trustee can make a debtor turn over property to a creditor if there's a valid security interest. And the trustee will say, okay, if you're not going to redeem this, and if you're not going to reaffirm it, this creditor has a valid security interest in this piece of property that you still have. You don't get to keep it if you're not going to pay for it. I have seen trustees set up dates and times or facilitate setting up dates and times for a creditor to come and pick up a vacuum cleaner that's been financed. I've seen a trustee facilitate a creditor coming and literally taking windows out of a house. I've seen it happen. Remember, the trustee's job is to protect the interest of the creditor. If the creditor wants those windows back and you're not going to pay for them, come get them. Come get them. Same with vehicles. Vehicles are very common, and lots of times a trustee will facilitate or will encourage the attorneys to set up a time so that the car simply gets returned to a dealership, so that you don't have to go through the whole, someone shows up at your house with a flatbed and puts the vehicle on it. Okay? The trustee sometimes will get involved if it's a tough situation. Hopefully the attorneys will facilitate it, and whoever has the property, the personal property or the real property, will cooperate. There is a duty in the bankruptcy code for the custodian of whatever it is to return it. What if, I bought a vacuum cleaner and I financed it, but I gave it to my daughter? My daughter's the custodian of the chattel, of the collateral. We've got to make sure that it gets back if I'm not going to reaffirm it or redeem it. That's how it works. Okay? What happens if there's been a fraudulent transfer of property to avoid property going into a bankruptcy? Okay? This gets really messy, because people try and do this all the time. And again, this is a lot like divorces, where someone will say, hey, I'll sell you that four-wheeler for $50. Hey, just hold it for me until after the divorce. Right? Same thing with bankruptcies. Hey, I'll sell you the four-wheeler for $50, and you can give it back to me. I'll give you $100 after the bankruptcy's over. Okay? You can't do it. Section 48 of the Bankruptcy Code says that the trustee can get back anything that's been fraudulently transferred while the debtor's insolvent. Okay? There is a look-back period, and if you've transferred something that is not reasonably, if you're not paying what's reasonably the value of whatever it is you are transferring or selling to somebody, the trustee is going to say, sorry, give it back the four-wheeler. We're including that in the bankruptcy. Okay? There's a list of things, that the court will consider. The transfer was made at a time when the debtor was insolvent. It caused the debtor to become insolvent. It left the debtor undercapitalized for current or planned business transactions. It was made at a time the debtor had or planned to incur other debts beyond its ability to pay. And it was for the benefit of an insider. Okay? So if you're selling it to a family member, right? Don't. In wills and trusts, we learn about this thing called a constructive trust, where you are transferring ownership to somebody and they're really just holding it for you. And then the intent is that it gets returned to you at a later date. That's what we're really talking about here. But the problem is, when you do that, you are committing a fraud on the court. And the court can say, get out of here. We're not even going to hear your case anymore because you're trying to defraud the court. Okay? The same thing will happen if you have preferentially transferred property to one creditor over another. What does that mean? What if I gave $150 to my father-in-law because he loaned us money, but I didn't pay the other creditors? Well, that $150, my father-in-law is going to have to give back to the bankruptcy court because that was a preferential payment to a creditor. You can't do that. You basically don't pay anybody. Now, that becomes a problem if I'm going to reaffirm a debt, right? What if I plan on reaffirming my house? That's kind of your exception. If you plan on reaffirming and you give that intent, right, in the schedule that says notice of intent for reaffirming, it will make sense. Okay, you're going to reaffirm this one. It's not a preferential payment. It is continuing payments that you're going to pay even after the bankruptcy is over. Okay? What the court looks at is 90 days prior to the filing of the bankruptcy petition. That's our look back period, 3 months. So if within 3 months of filing your bankruptcy petition, you go hog wild shopping, you take that MasterCard and you go to Target, and boy, you can spend a lot of money at Target, and you charge up a bunch of stuff a month before you file for bankruptcy. Bankruptcy court's going to say, that's no good. That was, you knew you were insolvent, and you knew you were going to file for bankruptcy. Nope, we're not going to accept this. Or if I make preferential payments to one creditor over another within 90 days. Or if I take money, or I pay money to, if I transfer something like my snowmobile to my brother-in-law and I don't get fair market value for it within 90 days. 90 days is the look-back period, and the court is very particular about that. You had better just be sitting still for 90 days, paying cash. That's it. Not charging anything for 90 days. Otherwise, the court is going to find those to be fraudulent and non-dischargeable. You're going to have to end up paying it in plain English. Okay? What if I filed my bankruptcy petition and then I sell something? Can't do it. Can't do it. It doesn't belong to you anymore. You've already said to the court, please, bankruptcy court, give me help. And so the bankruptcy trustee and the bankruptcy court say, sure, we'll give you help, but you got to follow the rules. Everything that's in your estate stays put, so that the bankruptcy trustee can evaluate whether or not things need to be liquidated. You don't get to liquidate it. The trustee does. Now, are there situations where you can say to the bankruptcy trustee, I have a buyer for? Well, then you're working with the court. But if you just sell it on your own without talking to your lawyer or the bankruptcy trustee is going to hunt down whatever it is you thought you could sell, nullify it, avoid it. Avoid is the term. And you are not going to, any money you got for it, you're going to have to give to the trustee or give back. Okay? Time limitations, the trustee, once they know about it, has a time limitation to say we are going to have a proceeding here to get this back. And the trustee can actually file a lawsuit to get the property back. Okay? So the moral of the story for this particular chapter is sit still for 90 days before you file for bankruptcy. Don't do any kind of neat, sneaky little tricks like, hey, if you hold this for me till after the bankruptcy, we'll be cool. Nope, don't do that. It's fraudulent, and actually your entire petition for bankruptcy can be kicked out. And don't sell stuff after you filed for your bankruptcy petition without saying to the trustee, hey, can we get permission? Do you think this is fair market value? Is this a good price? The money will go into the bankruptcy estate so that you can distribute it to creditors. Those are the important ones. And if you're a creditor, you better file that proof of claim. If you don't file the proof of claim and it doesn't lay out what's pre-petition interest, what is a copy of your financing statement, all of that stuff. If you don't have that, you're out the door. Somebody else will step in front of you. And the bankruptcy trustee will pay them first. Okay? All right, that's it for this chapter. For week 8, there's a discussion and assignments, so make sure you get those accomplished. Again, if you have any questions, please reach out to me. I'm more than happy to answer questions for you. Okay? Thank you.